The California Residential Purchase Agreement form is the cornerstone of every successful real estate transaction in the state of California. In this training video, we will review how to properly complete and use the RPA form step by step to better serve and protect yourself and your clients. This training is not intended to be a substitute for the advice of your broker, nor that of your attorney. We will cover paragraphs 21 and 22. Our instructor for this video is Kevin Burke. Let's get started.
So this is paragraph number 21. This is the whole paragraph. Now I'm going to break it down into its component parts here in a second. Here is 21A. So 21A, I'm not sure if that's easier for you to see or not, but we are going to talk about it anyway. So there's a couple of big words in 21 that I'm going to tell you not to use in your vocabulary. Okay, so because some of them they're just legally charged, and we want to be careful about that. So for example, here we are, paragraph 21. First word out of the chute is remedies. Okay, so remedies is a class in law school. It lasts for a year, and it is one of the toughest classes you're going to take. So if you decide to go to law school, remedies is you're going to have to take it. It's required. It's a whole year of law school. It's a blur. I mean, it's just so much stuff. So because it's such a complicated issue, we want to be careful about using that word in our everyday language. I mean, we realize that, we like the word, it's cool, but it's right up there with breach, right? So breach is another legally charged words. So we want to probably not use these words because we don't want to give people the impression that we're giving them legal advice at the same time that you have a real estate license that says that you can give real estate advice. But when you start using charged words like that, I can tell you pretty much any attorney that I talk to is going to say, I don't know if I do that, because you really don't know what the answer is. And so a lot of times we think we know. All you got to do is watch the Supreme Court at any day, and then you'll hear things that you just can't believe what are coming out. And your interpretation of the law may be very different than the interpretation of the law of others. So, and unfortunately, you're subject to that trier of fact, otherwise known as a judge or an arbitrator or that. So let's be careful about using those words, okay? So that's just kind of my regular out of the chute admonition. But again, remedy means what happens if, and what are we going to do about it? Breach, again, is a charged word. It says that you did something in that contradicted the contract, and understand that this whole thing is about the buyer's breach, not the seller's breach. Okay, so people sometimes they don't think about that. They think, wow, this is what happens if something goes wrong in the contract, and the answer is no. This is what happens if the buyer does something in the contract. So what happens in the event of the buyer's breach? So any clause, now this is one of my favorites, okay? So, because we used to see this all the time. I mean, most of you that are on here right now have seen it before. We talked about it. What happens when, you've heard things like pass-throughs. I just had a contract the other day where they wanted a pass-through. They wanted money given to the seller. They wanted the buyer's deposit released to the seller. So let's look at what that clause says. So it says, any clause, okay, any clause added by the parties being the buyer and the seller, remember, and you may be the one trying to do it, and you are going to become one of the parties if you do it, okay, because, essentially you are giving legal advice at this point. But any clause added by the parties specifying a remedy, okay, such as release, forfeiture of deposit, or making a deposit non-refundable. Now, we've all heard this before. The money is to be passed through to the seller. You know what? You pass it through to the seller, then it pretty much looks like it's non-refundable, right? Good luck getting that back again. The issue is for failure of the buyer to complete the purchase in violation of this agreement shall be deemed invalid. In other words, it doesn't function unless the clause independently satisfies the statutory, that's the law, liquidated damages requirements set forth in the civil code. And by the way, this is not that paragraph. So the paragraph that we have specifies directly to this purchase agreement But the language that you need to have if you're going to create a pass-through or a non-refundable deposit or whatever you want to call it, it requires that it's going to be invalid unless, because and that's legal advice, unless it satisfies the statutory requirement, and this isn't it. In this language in this contract doesn't satisfy that. So, but we still see it. We see it, with people that have been around for a long time. I'm always worried about people that have been doing this thing for 30 years. Maybe they've been doing it wrong for 30 years. I don't know. I change with the times. I do whatever, the current agenda looks like. But I can tell you that there are still people out there trying to do this. And so here's the thing. So if you try to do it, it's going to be held to be invalid. And the reason we put this into the contract is because we wanted the parties to know that if their agent suggests doing it, that it's still going to be held invalid. Okay. And the agent that steps up and says, let's do this, is essentially the client's looking at him going, well, I guess it's legally okay. And the answer is it's not legally okay. It has to have that language. And the minute that you try to draft this language, the minute you try to draft this, that's you are definitely giving legal advice. Okay. We want to stay away from that as much as we can. So I had an agent in our office a couple of years ago who no longer with us, of course, but owned property in Santa Luz, and it was like $4 million. The buyer was writing an offer. The buyer wanted to make their offer look more solid. So the buyer wrote in their offer, and the seller agent, our agent, was insisting that $250,000 were to pass through to her at the time of the contract. Okay, it can happen at any time. Money doesn't need to be passing hands until the title transfers from seller to buyer. But in fact, here, they all agreed that they were going to do it, and then I refused to allow it, of course. And so now I'm the bad guy. So I referred the agent to a really good real estate attorney in Rancho Santa Fe, not cheap. And she gets back the document that would allow the transfer of the pass-through of money from the buyer to the seller, and it was 5 pages long. And so how many times, when's the last time you drafted a 5-page contract? I hope not, right? Okay, so I hope you're filling in the blanks and you're using the standard forms and you're doing things like that. But if you were to sit down, this was a work of art. I love this. It was so good. In fact, I keep thinking about it. I'm going to go back and find it. Except that I can't really publish it, but it's just like, wow. So if you thought it wasn't complicated, it's incredibly complicated. And yet I still see people do it. So the answer is don't do it. This is what it's going to talk about. If in the event that you try to do it, it's going to call it invalid. And again, remember, if as I said in this morning's class, as long as everything's going along fine, everybody's agreeing to everything, we think it's okay because we're getting away with it, right? But the minute that things go bad, that's the minute everybody starts lawyering up, and the next thing you know, you're going to have a problem, and it's going to be a serious problem. And if you were the one that was involved in creating this language, then guess what? They're going to say you were giving legal advice, and they're going to come after you for that. Of course, me telling you that is legal advice, right? I'm going to tell you don't do it. Make sure you discuss this with your broker. Make sure you discuss this with counsel. So, in the scenario I just had, it might have been a week ago, I sent over my response to the other side was, have you read paragraph 21A? And then after that, it was interesting because they came back and they said, it was a good broker, by the way, standalone broker. So good broker. And he goes, my God, I never even saw that. It's like, oh, we've had it in the contract now for since October of 12. It's been in the contract. So it's just because we saw too much of it. It was creating so many lawsuits and creating all kinds of problems for us as agents and as brokers that we just want to make sure that we're not doing it. Okay. Is everybody good with that? Does anybody have any questions about any of that? Because that is just a hot charged item. It's going to get you in trouble. So, oh, hi, Betty. Okay, so I'm just looking around to see who I got here today. Okay, good. All right. So that being said, then if there's no questions on that, which I'm kind of surprised, but okay. So those of you that are in this webinar that are in my office, we don't do that. Okay. So, we like our real estate license, and God knows we love our broker, right? Please, we love our broker. Take care of your broker. Ask your broker if you got somebody who wants to do something like that, and we'll say no. There it is. Okay. All right. No questions on any of that. I'm going to go ahead and move us forward, and I'm going to take us to. So that was fun. I guess that was fun, right? So don't do pass-throughs. Don't do non-refundable deposits. Resist the temptation. You know, some veteran agent says something that sounds really cool, and now you go, wow, I'm going to use that in the next deal I'm doing, and it's like, I wouldn't probably do that. Okay. All right. So let's talk about my liquidated damages provision. So, and by the way, on liquidated damages, I spend 3.5 hours on this in my law class. It won't be this evening. This evening we're just getting going, right? So, but I spend 3.5 hours on this alone. So, but let's break this thing down in its component parts, okay? So I'm talking about liquidated damages. So remember, if I'm talking about liquidated damages, I'm talking about what happens when other than actual damages. So I'm gonna blow your mind here in a second. So liquidated damages is what's the word I'm looking for? Is intended to create a break from a free fall for a buyer in a declining economy. So it limits the damages of the buyer to the seller. So the seller, by agreeing to liquidated damages, says, okay, fine, if I'm selling you my house for $1 million and you back out of this deal and you don't have a good reason for backing out of it, and at the time that you back out of it, my house went from $1 million to $800,000, then the damages are going to be $200,000. Okay, so does everybody understand that? $200,000 damages, that's what actual damages look like. And it could be more, it could be costs, it could be things like that. So, but if the value of the property drops 200 grand, the buyer says, oh my God, I mean, that's a lot of money. And I didn't have it anyway, I couldn't close the deal, right? And so the buyer says, listen, I want to limit what the seller can get from me by limiting that and by doing what we're going to do is a liquidated damage. And again, as we break into the component parts, and I'm looking at my clock and I'm going, how am I going to do this in another hour? So okay, so if the buyer, again, this is the buyer, if the buyer fails to complete this purchase because of the buyer's default, okay, this is a remedy for the seller, okay, it's a remedy against the buyer, the seller shall retain as a liquidated damage, and you can Google that and you will see that that's a number. We're going to talk about how they arrive at the number, where that comes from, the deposit actually paid. Okay, so in this case, if the buyer defaults, again, because of the buyer, something the buyer did, then the seller gets to keep the deposit. All right, so we never want to make that statement when we're talking to our client. You never want to say you're going to lose your deposit. I always say your deposit may be at risk, because it may take a judge to determine whether you lose your deposit or not. It is not my place to do that. And because I don't give legal advice, my statement is always your deposit may be at risk. So Pamela, it might be at risk, not you're going to lose it. Okay, so because we have people talk to us like that and we go, oh, wow, they must know something that we don't know. And the answer is no, they don't. They don't know what we don't know. We know that you can't make that decision on whether or not you're going to lose it. But here's the bottom line. This says that the seller gets to keep the deposit. So let's say our transaction, let's just, for laughs and giggles, let's put some numbers up here. It's $1 million. Sorry about that. My pen is skipping. $1 million transaction. And the buyer is going to put down a $50,000 deposit. Okay, and I'm going to call this an EMD because that's always been, in my world, it's always been a earnest money deposit. All right, so I've only been doing this for 41 years, and we just called it that up until about 10 years ago. And I don't know what happened, but they changed it without checking with me. I like earnest money deposit rather than initial deposit, but they created the term initial deposit to separate it from the down payment. Okay, because those are two different things. Okay, so now, the transaction falls apart, and at the buyer's fault, how much does the seller get to keep? The deposit actually paid. Okay, $50,000. Well, we come along with this language that says, well, wait a minute, we don't necessarily want, what happens if the buyer puts down $150,000? Let's do that. Let's put down $150,000. You think it's okay for the seller to get all of that? And the answer is probably not. So let's go ahead and let's take a look. Now, the parties are being asked to agree to this, and I'm going to tell you not to have your client sign this just because there's a place for them to sign. Even in zip forms, when we send it to the client for signature, it is an optional, for initial, it is an optional initial, not a signature, but it's an option. They don't have to do it, and here's what's going to happen. So in this scenario, when I get up to this point right here, I'm going to put a bracket around it. At that point, the seller gets to keep the 150, right? Okay, so let's talk about that. If the property, and one of you the other day really raised a great point, and we're going to hit on it again here in a second. If the property is a dwelling, so that's going to be a residential 1 to 4, right? Because remember, the residential 1 to 4, it's a single family detached home, it's a duplex, a triplex, a fourplex, right? Once we get into a 5-plex, we're into commercial. So in a commercial transaction, UCC will prevail. So the Uniform Commercial Code will prevail. Someday I'll show you the Uniform Commercial Code book. I've got it around here in my library of law books. But it looks like a Merck manual, right? I mean, it's only about that big. And you look at it and you go, how come that's only that big, but the California Civil Code is like covers a wall, right? And the answer is because in Uniform Commercial Code, everybody's got lawyers anyway. So we all know we're going to court, okay? All right, so if it is a dwelling, okay, residential 1 to 4, okay, again, remember the purpose of this contract is a residential 1 to 4. If you're using this to do a 5 or greater, then you're in the wrong form anyway, okay? All right, with no more than 4 units, there you go, okay, one of which the buyer intends to occupy. What happens if your buyer's not going to live in it? What if it's a single family home and the buyer's an investor? Then this may not apply. Okay, so yeah, that's kind of a surprise. All right, so I wanted to bring that up, okay, but one of which the buyer intends to occupy. Let me erase all this so we can see what we're doing. Okay, wow, that's cool. Okay, then the amount retained shall be no more. What did I do? Oh, could have put on the eraser, sorry. Okay, the amount shall be no more than 3% of the purchase price. Now, where did 3% come from? So 3% is kind of a statutory number. I've seen contracts with 4%, but the courts are pretty good about 3. I've seen them at 4, but that's in commercial. Okay, and so, you know, again, when we get up into my commercial world, then it's going to be a whole other set of rules. All right, but it shall be no more than 3% of the purchase price. Okay, so in other words, in my scenario here, I've got $1 million transaction. The buyer put down an initial deposit, an earnest money deposit of $150,000. How much can the seller keep at this point? Let's say it is a dwelling, it is a residential 1 to 4. Let's say the buyer is going to live in the property, so the seller now would be able to retain no more than 3%, which would be what, 30,000, okay, because that would be 3% of the purchase price, okay, and then any excess shall be returned to the buyer, okay, so the seller gets the 30, the buyer gets 120 back. Everybody good with that so far? Important point. Oops, I'm sorry. Somebody had a question. Okay, good. Let's take a look. Maybe you are getting there, but can you share when you would recommend or not recommend the initials? James, you always ask good questions, and let me tell you, I'm not gonna recommend, but I'm gonna tell you how to handle it. Okay. All right. So here's the thing, because there are situations where I recommend it. If I'm representing the buyer, I think the buyer should be doing it. I don't tell the buyer I would do it because that's a legal decision, right? And I don't ever want to do that. But you know, I frequently have, and for those of you who are my students in the colleges, you know that I always said, you know, here it's in bold print, folks. It's in bold print. It's very powerful. It's like, I'm not going to tell you what it says. Okay. I'm just not going to do it. However, what I will do is I will say, let's take the agreement. Right. And I'm always reading it upside down, right? Cause I'm better reading it upside down than I am right side up. I just, you know, I don't know, maybe I'm dyslexic, but I just kind of learned over the years, decades, how to read it better upside down. So I'll turn around and say, I don't know what it says. Let's read it together. And so, in that, you need to write that down. I say it all the time. I'm not sure what it says. Let's read it together. And I find that when I sit with my buyer and my buyer reads it with me, the buyer gets it. And the idea is now they got the meeting of the minds. And that's what's so cool about my business. I watch the lights going on and they're like, oh, well, it says right there that it's a dwelling. with no more than 4 units, and it's only a home. I'm buying a one, right? I do intend to live in it. The seller can only keep 3% of the purchase price. So remember, rewind, go back to my paragraph number 1 where it says how much money are you going to put down, how much you're going to sell the house for? Well, $1 million, right? And so this is where agents come up with this, the deposit, the earnest money, the initial deposit amount to be $30,000, because in their brain they know coming up soon is going to be a paragraph that limits the seller's recovery. So my question is, why are you doing that? But here's the thing. However much money you put down, if there's an issue, then later on, then we're gonna have to deal with that. If it's 150 grand and the seller says, I'm not buying it, the seller says, that, yeah, I initial liquidated damages, but I think you did all this other stuff. Now 150 sits locked up. They don't just give you back the 120. It just sits locked up while you wait for a judge to make a decision. And that's why sometimes people will say, well, I don't know, I want to put 150 into it, but I am willing to risk 30. Okay, because it looks like the limit of my liability would be 30, but I do want my offer to look powerful enough to beat out the other offer that's paying cash or something like that, right? With no earnest money. All right. I have scenarios right now where the agents all agreed to $10,000, and so and some of you here right now, I've had this conversation with you. If your seller and your buyer agree to $10,000, then it may not be for the initial deposit. Then it may not be enough for them when it comes time for litigation, right? So, why? Because you're going to be in small claims court, which is like the Wild West, all right? And there aren't too many attorneys, and I've referred these to attorneys. And they're just like, you know what, you guys just go take care of it. You did it at 10,000, go to small claims court, roll the dice, take your chances. And I've done that enough times where, I win, right? But at the end of the day, what do you know that's stress for? Okay. So I don't know. I don't know what the answer is to that. Other question, Betty. If the buyer's initial liquidated damages and removed all their contingencies, okay, let's get to that in a second. Let me finish the paragraph really quick, okay, Betty? Don't let me get off without answering your question, but I do want to finish the paragraph. So everybody understands that it's going to be 3% of the purchase price, any excess it'll be the deposit actually paid, but no more than 3%. Okay, so they put down 150, but no more than 3% of it would go to the seller in the event of the buyer's default. All right, okay, except as provided in 14, and now I'm going to have to erase some of this. Wow, oh, that works. Look at this. Oh, how cool is that? Okay, all right, so back to my drawing. Okay, so except as provided in 14H, release of the funds will require, 14H members' time periods, will require mutual signed release instructions from both the buyer and the seller, or judicial decision, the judge, or an arbitrator's award, okay, arbitration award, okay? So in other words, that even though we agree that the seller gets to retain 3%, okay, if that's what assuming everybody agrees to it, then it's still, and then the buyer says, no, I'm not going to do it, even though you're in the middle of the transaction, the buyer defaults, buyer gets out, buyer doesn't have a contingency or whatever. Even if the buyer has a contingency, it doesn't automatically go to the buyer. So you'll go to the seller. So never, ever tell your client they automatically get the deposit. That is a legal decision. You are going to cook for that. Okay, so never tell the buyer that the buyer is going to get their money back. Never tell the seller that the seller is going to get the money. You need to resist the temptation to do that, because somebody else is going to tell them, right? But they're going to be wrong, and they're going to hope that as circumstances unravel, that they won't be wrong at the wrong time. All right. So let's take it. I just want to summarize this really quick. I don't want to erase all of it. I just only want to erase some of it. But see these people down here? I've got either the buyer and the seller are going to agree, or more commonly, it's going to be a judge or an arbitrator who's going to do that. Okay. Question. I got another one here. Doesn't intend to occupy. Okay. Let me finish here. Hold on a second, Claudia. I got you. Okay, so at the time of any, sorry, I keep forgetting to erase my eraser. At the time, notice this is in bold print, 10-point font. At the time of any increased deposit, buyer and seller shall sign a separate liquidated damages provision incorporating the increased deposit as liquidated damages. And that's going to be CAR form RID, which is the receipt for increased deposit. Okay. Now I'm going to give you a copy of that, and we're going to go to that here in a second. But the point is that the money that is covered by the liquidated damages provision it covers only the original money that's brought in. It is not going to cover any other money that you bring in later. So sometimes, you'll have a contract where it'll say that the seller, that after the buyer removes all of their contingencies, on day 17, for example, that the buyer will bring another $50,000 into escrow. Okay. Now, again, that's not being passed through. That's not being given to the seller. That's not being called non-refundable. But unless you want that to be, if you want it to be covered by the liquidated damages provision, if everybody has agreed to this one, if everybody's agreed to this one, do you want that additional money coming in also being subject to liquidated damages? Because if you don't use this form, it becomes subject to actual damages, and that's going to create some problems in your contract. So that's why we did this. That's why we wrote in this paragraph, so that everybody understood that increased deposit, whatever it is at whatever time that comes in, then that means that money would be, it's not covered by liquidated damages unless you use that form. Okay. All right, so I want to get to your questions, but first I want to pull up the form real quick to show you what I'm talking about. Oh, shoot, I can't do that. I got to go to mouse. Hang on, because this is good stuff. All right, make sure that you can see it. He says with confidence as the form is pulling up. There it is. Okay, so let's take a look at this. So increased deposit. Can you see that? I think you can, right? Yeah, you can. I have my other computer over here, so I can actually see what you can see. Okay, so here's my increased deposit liquidated damages addendum. This is what happens when I bring in other monies after the initial deposit. Okay, and here you go through all the language, and then you get down here to paragraph. Okay, up at the top, what have I got? That's my linking language. Links this agreement with the other. Okay, with the rest of the contract, okay, because I want to be able to do that. Now the buyer is bringing in additional money. Here it is right here. And then here we got paragraph number 2 that says that we want the liquidated damages provision either or not incorporated and made part of the addendum, okay? And so you see in here, same language that you saw before in the other part, and it says everybody's going to either want that liquidated damages or not want that liquidated damage. So the reason why we have the form is because it may be that the buyer doesn't want that to be subject to liquidated damages. The seller may not want it to be subject to liquidated damages. We're going to have to make a decision on that at some point, okay? Everybody good with that? Okay, I'm going to I want to do your questions now too. Let me see here. Wow, it erased all my stuff. Okay, cool. All right, let's take a look at, y'all had some good questions. I didn't mean to shine on them really quick here, but okay. I want to answer first the question of, should you recommend or not recommend that your client initial? Now, that is, who asked that? That was good. Is that Claudia? James. Okay, that is a good question. Let me tell you why. Because I'm not going to tell you. I don't know. I tell my client, I don't know. Do you want it to apply or don't you? And again, when they say, well, what does it say? I say, well, I don't know. I teach it. Okay, I don't know. I say, well, I don't know. Let's read it together. And then when we read it together, so now you and I have just done that. We've actually drilled into this. Now we had a little guidance along the way, right? Okay, so it's not like you're reading it on your own. But here you had a little guidance and you read through it. Do you get it? Does it make sense? It says I'm going to shield the buyer from in the event of a free fall. Okay, but what's going on today? All right. Now remember, your market changes, and this is the huge advantage that you have. So the market changes today. The market is it in a free fall? The market is going nuts, and I'm talking about across the country. It's going nuts. Property values are going up and up and up and up. And so if this is intended to shield the buyer in the event of a free fall, then maybe they don't want to sign it. Right? Think about it, okay? So if the market is in fact going up, what damages does the seller experience if the buyer defaults, okay? Now I don't want you to be overthinking this, and please do not share this. Again, have your broker call me, whatever, let's talk about it. But at the end of the day, the provision is intended to protect the buyer in a free fall. So if it's there to protect the buyer in a free fall, then maybe your buyer doesn't want to initial it because it's not in a free fall. but your seller does. Why? Because the seller wants it initialed because it's not a free fall. But here now the buyer is giving up money, saying, I don't want to take any chances. I want to limit my losses in the event that the market turns in the middle of our contract, which is possible. Okay. All right. I've seen markets change on a day. How many of you watch the stock market? All of a sudden one day, boom, in the tank. Next day, it's up here again. Okay, it happens. So that's why we got to be really careful about giving advice on what to do here. So in a rapidly declining market, the buyer clearly wants liquidated damages, right? I don't want to pay 150 if I can just pay a 30. Okay, right? Assuming that there's recovery, okay, recovery by the seller, okay. But on the other hand, the seller wants it, right? Because now they're getting a blank check. They're getting a free check for 3% because the buyer has agreed to let them have 3% regardless of the market. You follow me? That's why B is so problematic for us. If the market is going up, the buyer doesn't want to initial it because they're giving up $30,000. But the seller wants it because if the market's going up, then the seller says, yeah, it's going up, but I want the 30,000, right? So, I wouldn't have a loss except that now you've agreed to give me $30,000. Is everybody clear on that? That it's so think about it. And it's one of those things you have to say, let me step back for a second and listen to this. But the bottom line is, if the market's declining, the buyer wants it. The buyer wants the protection of it. The seller doesn't. The seller says, I want the 150, right? But the buyer says, I only want to give up 30. And so I want this clause. And the seller says, no, I don't want this clause. In an improving market, which is what we're in right now, the buyer says, why would I give him 30 grand? He's not going to have any losses. I'll cancel and they'll sell it to somebody else for more money. But if I sign this, if I initial this, then I lose my 30 when there was no loss to the seller anyway, and they're going to sell the property for more money. Okay. Of course, the seller in an improving economy, they want this initialed. All right. The buyer doesn't, right? I'm sorry, back up, start that over. So in an improving economy, right, the seller is going to see no damages at all. So they want to be able to keep this deposit. You follow me on that? Everybody good? So think about that. Let that sink in a little bit. But so to answer your question, James, I don't know what to tell you. I always tell my client, I don't know. Now, the reality of what happens in real estate is that, you'll write an offer on a property and then the other agent who's, been in the business for, 12 weeks or whatever, sends you back a counter and says, no, I want, seller wants it. Everybody wants it. And you sit there and you say, I just say many a time, I go, really, did you really have the conversation with the seller? I mean, in this economy right now, yeah, the seller probably wants it because they get a free $30,000, right? Because they're not going to suffer a loss. They're going to resell it for more money, right? But did you actually have the conversation with the seller? And then woe be to you that maybe the market shifts in the middle of your transaction. And that's usually when the buyer is trying to get out anyway, okay? All right, so it's a more complicated issue than we think. We have drilled into this, spent an awful lot of time on it because I want you to be very careful about how you say to the client whether or not they should initial it or not. Your answer is, I'm not going to tell you what to do. It's what do you want to do? The reality that you and I face is that the listing agent's probably not in this class right now. And so they're probably, well, I was always told to initial. Everywhere there's initial, they should initial it. And so the next thing you know, you get this thing that says everybody agrees to initial it. Remember, your counteroffer form says right in there that if a paragraph of the contract requires a separate initial, 21 and 22 requires a separate initial and one party doesn't, then the buyer doesn't initial it, the seller wants it, then the counteroffer has to address it, otherwise it doesn't apply. Okay, so if your buyer doesn't initial it and the seller doesn't catch it, okay, and the seller just doesn't initial it either, then you don't have liquidated damages, you have actual damages. All right. And the lawyers have a ball with this. Okay. So, and it's funny because I know that I've got lawyers watching me right now and they're just laughing because it's like, God, he gets so excited about this. This is an exciting paragraph. Okay. But it's one of those things where we need to be really careful about what we say. Okay. It's one of the many. Okay. So let me hit another question. So James, thank you. That was an excellent question. Betty, if the buyer's initial liquidated damages and has removed all other contingencies, so I'm going to put in there, the buyer has initialed it and the seller has initialed it. So now you're saying liquidated damages applies. They've removed all their contingencies except for the loan on a personal residence. So I'm assuming residential 1 to 4, and have been approved for loan, but after being in escrow 2 months, decides he doesn't like the interest rate that the lender is giving him, and he cancels the contract, does the seller get the liquidated damages less than 3%? That doesn't make any sense, but okay. All right, so here's the thing. The buyer's loan contingency only applies during the loan contingency period. Okay, so if the buyer's loan contingency by the current contract is 21 days, we're changing it in the one that's coming out in December of 21. But the current contract says the buyer has a loan contingency for 21 days, unless you've altered it, you in your offer or in the counter offer, it says 10 days or whatever. But during that period of time, the buyer, the buyer has told the seller, because remember we filled out paragraph number 3 to say what those contingencies are, that it may not exceed 3% or whatever. Interest rates, I just got quoted 2.75. Okay, but that's why you have to put those numbers in paragraph number 3. Otherwise, the buyer can't say, I don't like the interest rate. You can't just not like something. You have to have something material. It has to be something big to get out of the transaction. You got to be able to put your finger on it, not I didn't like the loan, or the weather wasn't so good today, or my ice cream melted, or something like that. You come up with some crazy thing, okay? So you can't have a reason like that. So they've been in escrow for 2 months, whatever, that doesn't matter. And actually, this looks like a real estate exam question. Doesn't like the interest rate the lender is giving him, and he cancels the contract. Buyer can't unilaterally cancel, but I think you already know that. You're saying that. Does the seller get the liquidated damages? So the answer is, if it's an argument about whether or not the buyer can exit the transaction legally, that's going to be a judge, an arbitrator, whatever. Okay. But does the seller get the money? And the answer is they don't get anything until one of them tells you that it does. And so the buyer can't unilaterally cancel, but the seller could just give it up and say, yeah, here, go on. I'm going to go resell my house, because I can't say you have a contract and then me try to sell it anyway. All right. So, well, I've had sellers do that, but it's like, it doesn't usually go well. Does the seller get liquidated damages less than 3%? Well, if liquidated damages in this case was $30,000, so if that was our liquidated damage, remember in our scenario, then the seller, hypothetically, if the buyer didn't have a good reason to get out of the transaction, then the seller might be entitled to the recovery of the $30,000, assuming that everybody initialed the paragraph. Okay, the key to take away, I don't know where 20,000 comes from, but the key takeaway in all of this is it is a much more complicated paragraph than most people give it credit for. And so I do trial work on this. So when I get in here, but see, this is something I normally don't get called in on. So like, by the time the liquidated damages is being pursued, it's because of something else that happened. So something happened in the transaction, like the buyer tried to get out, okay, and now the argument is over, do we keep the deposit? Had a really good lawsuit in Del Mar probably about 25 years ago now, where the buyer and the seller, they had gone under contract to buy a home. It was right across the street from the then City Hall on 10th Street, and they were using it as TV station, all that, and there was a rumor floating around that that building was going to be used as the new firehouse. Well, the buyer decided they didn't want to buy the house, that they were going to be right across the street from the firehouse. I guess they don't like the sound of, when people get up in the morning. Okay, so they decided that they weren't going to buy the property, and then the two of them sued each other. The seller sued for the deposit. So, and they did. They went after the buyer's deposit. It wasn't just, cut a check. And the seller, Mrs. Seller, happened to be an attorney, and so they sued over the deposit. There was no lis pendens. I ended up selling the house. There was no lis pendens because everybody realized we're only suing over the deposit. We're not suing over the property. So again, you don't think things get complicated. They get really complicated. And by the way, the seller prevailed in that and got to keep the buyer's deposit because the buyer really didn't have a good reason. They just kind of felt like they didn't want to take the chance they were buying a property that might have a fire station across the street from it. I think there had to be more to it because I probably could have done some real damage on that one. But again, I like the seller a lot. They were really smart, and they were my clients. So it was kind of nice to be on that side of things. But there was no money in it for me because I was just involved in the sale of the home, and I actually inherited it from the other broker, who was also a really good broker. He just happened to have bad timing with a bad buyer. That's all. So, okay, Claudia says, oh God, I'm running out of time. What if the buyer doesn't intend to occupy the property and puts down 150 and the buyer defaults? Can the seller get the entire 150? Could be. Okay, I'm never going to say, right? And you won't either. Don't say, okay, but what does the paragraph say? It says one of which the buyer intends to occupy. So if the buyer's not going to occupy it, then the argument is that they wouldn't be able to do it. Now, here's the thing. So I just showed you a second ago. Oh God, I hope you can see all this. Hold on a second. I got to make sure you're looking at what I'm looking at. Yes, you are. Okay. So, but I do also want to show you, let me take you to the other part of what's going on. And that's going to be, okay, get rid of that. I want to show you that there's a really good Q&A. There's a really good Q&A that CAR put out. So we have all these TLAs, right? Three-letter acronyms. So here it is. Can you see that? Yes, you can. No, you can't. Okay, now you can see it. So the quick guide. Okay, so this is going to be made available to you today. I thought they did a pretty good job on it. What are liquidated damages? Does the provision automatically entitle the seller to the deposit? All this stuff I'm telling you, folks, I'm sorry. This comes from the hallowed halls, as we say. May they agree in advance that the buyer will pay a non-refundable deposit? Generally, no. Okay, what you're creating if you try to do a non-refundable deposit is you're probably creating an option. And so options are very complicated, and you want to make sure you don't try to do one. We used to do them back up until the 80s. And then we just had too many lawyers. So, you know, I wouldn't write an option today on a bet, right? But, you know, I was doing them in the 70s, we were doing them in the early 80s. But by the time we got up to the 90s, I don't know, okay, it gets really complicated. So anyway, I'll send you this as well because I want you to have it, okay? Let's go back and take a look at where we were. If I can find where we were, Linda. Okay, all right, can you see? I want to get us back and get us out of liquidated damages because we're done. We're done. Any other questions on liquidated damages? Everybody good? Okay. All right. So that being said, let's take us to dispute resolution. So this is what happens if we aren't getting along. Okay, we're not playing well in the sandbox together. You know, what are we going to do here? So let's talk about that. So there are a couple of different options. We're going to talk about it in terms of ADR, which is alternative dispute resolution. So we all know there's always court, right? We can always go to the court. And if you've ever had that experience, it's expensive. It can take a long time to get there. The last lawsuit that I testified in took 3 years to get to court. And they had millions of dollars into this transaction by that point. Each side did. It was a lot of money. So what are the alternatives to that? And the law says, you know what, we got enough going on in the legal system. Right now, you can't even get into the court, right? Because they're all shut down because nobody wants to get sick or whatever. Okay, but let's take a look at what my alternatives are, okay? So I'm going to start off. This is my dispute resolution. The first one that we got to consider is mediation. So mediation is the default. You always mediate. You've all agreed by contract. There's no place to initial here. The mediation is by default, which means everybody agrees to mediate, okay? Now, if the mediation doesn't work out, or if you all get there and then decide it's not going to work out, then the next step is going to be, we're going to talk about either arbitration or court. Okay, so mediation, since it's the default, says everybody agrees to mediate their dispute or claim or any resulting transaction before resorting to arbitration or court action. It doesn't mean this is the end of it unless you decide it is, okay, through the, I don't know why they put a mediation center, so it's commercial, or through any other mediation provider. San Diego's got the REMC, which is really spinning everybody in the state, including CAR, because they like angry. They want everything to come to them, but you know, CAR is pretty smart. So, you know, CAR created the risk management and then the mediation center there, and it's just doing great. I mean, it's amazing. The attorneys that we have in there are just brilliant. So fun to watch, fun to listen to. So the parties also agree to mediate any disputes or claims with the brokers. So remember, you are not bound to go to mediation unless you have agreed to do so. So in your listing agreement, did you agree to arbitration with your seller? And remember, that's a separate form. So chances are today, since we removed it from the agreement and now we just have a reference to it, that probably you didn't do it. Okay, so in which case that means arbitration's out. That means you're going to litigate. The point is here between the buyer and the seller, do the agents have to come in? So the parties also agree to mediate any disputes. So now we've gotten everybody to agree to mediate disputes with their own parties or their own agents or other agents, but not sue them individually without at least attempting mediation. Who in writing agree to such mediation prior to or within a reasonable time after the dispute or claim is presented to the broker. So broker, unless the broker has already agreed to do it, there's no obligation for the broker to do it. My non-legal advice is that if the buyer and the seller are going to be mediating with each other, and again, mediating with each other, not against each other, because mediation assumes that we're going to come to an agreement, okay, then the brokers, I think the broker should go, even though they might not be party to the mediation between those two, but the broker wants to go because the first thing that's going to happen is they're going to throw the broker under the bus, if the broker's not physically present, okay? So that's the thing that worries me about all that. All right. So as a broker, yeah, we haven't had it happen in our office in all the years. But if there was a dispute between the buyer and the seller, then yeah, I want to be there. Mm-hmm. Yeah. Okay. Because I want to make sure everybody's being nice and we're not saying, well, the broker told me. And it's like, oh, another broker did not tell you that. Okay. All right. Mediation fees, because there are, if any, shall be divided equally among the parties. Okay, so the last mediation that I was involved in was a personal mediation I had in a real estate related deal, and it was against the homeowners association. I was obviously the plaintiff in that, and we each put up at the mediation, and each of us gave the mediator $250 because the mediator was going to charge $500 to hear our thing before they started to work on the mediation, and so we complied with the requirement to mediate, but we didn't have any intention of completing it, and neither did the other party. Everybody wanted to go to court, so we get in there, we hand everybody hands in $250. The mediator says to us, "Are you going to agree to be work with me on the mediation?" We all said no. We got up and left, and I prevailed at trial ultimately, but that was expensive. It was expensive for me to get there when the whole claim was really only over 18 grand and I won 88, but then of course the lawyers got a third of it, right? So we need to keep all those things into account, but the mediation fee is split at the time, so there's no favoritism one over the other. So if for any dispute any party commences, so if you start an action without first attempting to resolve the matter through mediation, this is important, or before commencement of the action refuses to mediate after a request has been made. So if you've all, by contract, everybody has agreed to at least attempt mediation. So if you start a cause of action against them for other than to toll the time period, okay, we'll talk about that in a minute, or if they ask you to mediate and you refuse to do it, then what? That party shall not be entitled to recover attorney's fees. Now, if you don't think that's a big deal, that's a big deal, right? So in other words, even though you're successful, you refuse to mediate, you decide you're going to go to trial. I have such a good case. You may not get their attorney's fees. You may not get your attorney's fees paid for by the losing party. So even if they would otherwise be available to that party in any such action, mediation provision applies. Whether or not the arbitration provision is initialed. So bottom line is that you don't want, if you, since we all agree by contract, there's no place for you to have a separate agreement. It says you agree to mediate first. So if you don't mediate first, or if you start an action, or if you don't agree to mediate when the other party asks you to do it, you can all agree to skip the mediation at some point. I mean, if it gets to a point where there's that argument, again, this is the lawyer's decision to make, not yours. Clearly not yours. But the lawyers can get together and say, oh, no, we're all going to, because lawyers can go to mediation with you, right? Okay, or represent you in mediation. Okay, it's not small claims court. All right. So, but you need to leave that up to the buyer or the seller's attorneys to tell them whether or not they want to skip that provision. But I've seen it happen where everybody skipped mediation and just went straight to court. And that's okay as long as everybody agreed to it, but that is rarely the case. Normally what happens is one party initiates an action and then forgets completely about this. And this is why I always recommend to you that you hire a real estate attorney if you have a real estate related issue. I've had cases where a general practitioner, somebody who didn't have any real estate experience, was hired to prosecute or be the plaintiff in a case, and it did not go well. Okay, so you need to have a real estate attorney. That's why people call me up and they say, I need an attorney, and I go, bingo. Okay, I got 26 of them. Okay, and guess what? They're all real estate attorneys, and they're all really good ones. And I was in a meeting with them yesterday for an hour, and I'll tell you what. There's some amazing stuff that comes out of their mouths. It's just phenomenal to me, but they know real estate law. Okay, and so although I can't tell you that, right, because I'd be giving you legal advice that they know real estate law. State law. Okay. All right. That being said, does everybody understand that? So whether or not This mediation provision applies whether or not the arbitration provision is initialed. So it's mediation first, then either arbitration or litigation, either one, okay? But you got to mediate first. Is everybody good with that? Okay. So the only scenario, the only question that we could possibly have, whoa, we got a bunch of them. The only question that we could possibly have is what would happen if somebody tried to skip it? And the answer is that's not going to work well, because you could lose your attorney's fees. And that's scary because sometimes those attorney's fees can be some zingers. Okay. All right. Let's take a look at my arbitration of disputes real quick here. So arbitration of disputes, this is a lot easier. Notice how I'm still in the world of bold print, okay? I'm still in that world, all right? So arbitration, it's a big deal. So it's arbitration or litigation, whichever you prefer. What happens if I'm going to agree to arbitration? So remember, there's a separate place to initial this. So parties agree that any dispute or claim in law or equity. Why do they say that? Because there are, hypothetically, there are two court systems in our country. One is a court of law, one is a court of equity. The court of law says, here's black letter law. Court of equity says, well, it wouldn't be fair. You know, we like fair, right? So that's like court of equity. It's just not right, okay? The Marvin v. Marvin case. In fact, I think I'm speaking on it tonight in the law class. Marvin v. Marvin. You know what? It was the court of equity. It wasn't a court of law because court of law says he keeps everything. But the court of equity said, it just wouldn't be fair. I mean, they lived together for 20 years. They bought property together. They were, using community funds. They're sharing checking accounts. She changes her name, but they weren't married. And so, anyway, so it's the famous palimony case and all that. So take a law class and I'll explain it to you, but it's fun. Which is not settled through mediation. So if we haven't resolved it, remember mediation is not binding. So mediation says that the mediator goes from room to room, back and forth between the two of you and tries to get you to agree to a deal. All right. That's what they try to get you to do. So I'll never forget it. It's like, they come into my, in fact, I was just in one 6 months ago. I was helping a party that was being sued. Actually, I might've been being sued myself. Well, no, I don't think I was. I don't think I was a party to it, but anyway. So anyway, the mediator looked at me and goes, "You pretty much know what you're doing, don't you?" I go, "Yeah, we're not gonna mediate." And they go, "I got it." And ended up being one of my students. He loved it. He said, "That was pretty good. I would have probably mediated that one either." I said, "No, we're not going to mediate that." So anyway, the judge agreed too, by the way. So, bottom line is, if we agree to mediate, and we get in the mediation room, and the mediator is able to get us to come to an agreement, then the mediator will now draft up the agreement and have everybody sign it. And the advantage to that is we just skipped the legal system. This all took maybe a day. They like to, if you start at 8 o'clock in the morning, they want to be out by lunch. Okay. So hopefully they can get something together where you can avoid the whole legal process and all the attorney's fees and all that kind of stuff. Remember, again, the attorney can be present during the mediation. All right. But, if they can get you to work out a deal and you sign it, now you are bound to that separate agreement contractually. Okay, because remember, it's not about whether or not this contract was good. It's about whether or not now the new contract, the contract that is discussing an element of the bigger picture, whether or not, it's not an admission of guilt or anything like that. It's just merely a statement that says that, this is, we're going to agree to this separate thing. I've had people do that. I've had people say, well, you know what, it's just not worth fighting over. Okay, and so that can be where it goes. Okay, so parties also agree to arbitrate any disputes or claims with the brokers. So same thing like my mediation provision, who in writing agree to such arbitration prior to or within a reasonable time after. Just like we just said a second ago, the dispute or claim is presented to the broker. So the broker gets to make that decision if they want to be involved in it. But the parties are agreeing that they will allow the broker into the arbitration as well, if the broker so wants to be there. And again, my non-legal advice is I'd probably want to be there, even if I'm only there as a witness versus as a party. But if I'm going there as a party, then I'm bringing my attorney. That's just how it's going to be. We're going to lawyer up. Everybody's going to have lawyers in the room. I've been in depositions where I've had 6 attorneys that I got to give free classes for. Well, not free. I charge them a lot of money for it. So bottom line is, who's the arbitrator? Shall be a retired judge, justice, attorney with at least 5 years of residential real estate law experience. Okay, you definitely want someone who's experienced in real estate law. So unless the parties agree mutually to a different arbitrator, I just don't know why you would do that, right? We've got our cousin Bob or somebody who's going to do it. But again, in our mediation center in in the building behind the main office, the 4845 Ronson building. You know, these are attorneys with experience in real estate, run brokerages, who've done things, you know, such as that. And here they are now acting as the arbitrator and probably pretty well qualified. Okay. All right. So I've always said that, listen, at least with mediation, with arbitration, I might get to the same lousy decision I would have gotten to in a court of law, but it took less time and cost me less money to get there. Right. But you never know. It's always a roll. You know, it's not even a roll of the dice, because it's frequently not even 50-50. You know, sometimes you think you've just got the winning case, you know, the winning case of the world here, and then you lose. But remember, in mediation, nobody loses. Everybody gives a little. But in arbitration, somebody loses. Arbitrator says you win, you lose, right? So that's what happens with the arbitration, okay? Same thing happens in the court of law, but I'm in front of an arbitrator within a couple of months. I'm in front of a judge within a couple of years, okay? All right. Parties shall have the right to discovery. Okay, now that's going to be important. Discovery, Code of Civil Procedure. Civ Pro is a year of law school, so please don't think you know what that says. In all other respects, the arbitration shall be conducted in accordance with all these rules. Judgment upon the award of the arbitrator may be entered into any court having jurisdiction. So in other words, if the arbitrator comes up with a decision, guess what? You can enforce it. Now, the arbitrator won't enforce it. You have to take it to a court of law. And that's an important point to remember. A lot of people come back, you know, they'll win in the arbitration in the back room there behind 4845. They'll win in the back room, but, you know, then they think that those people, you know, are going to help them enforce the judgment. And the answer is no. Turn it over to court, you know, boom. I would be filing an abstract, of course, of judgment, but that's what you're going to end up doing by going to court. Okay. So remember that you agreed or not to arbitrate, and you agreed to be bound by the decision. So enforcement of this agreement to arbitrate shall be governed by the Federal Arbitration Act. Exclusions we're going to talk about in a second. Okay, everybody good? Questions about any of that? Isn't that fun? God, I love this stuff. Okay, all right, let's go to the next part here. And where's my, oh, I've done it again. Okay, so I messed that all up. New share. Break open the new share. Where is it? Here it is. Nope, that's not it. Okay, clear everything. Oh, God, I hate it when I do this. Cancel, cancel. Leave without saving. Yes. Okay, good. I'm back to my screen. I learned how to do it. That's pretty good. It only took me about 12 years of college. Okay, exclusion from arbitration. Let's go to the next page. All right, now. Notice, now I want you to notice, it is in 10-point bold font. That is how important that is. Again, I caution you against explaining to people what this means. When your client says, what does it mean? The answer is, I don't know. Let's read it together, okay? And then let them come up with a decision. If they don't understand it, maybe you can go to your broker and have your broker explain it to them, but I wouldn't be doing that if I were you. I won't even explain it to them. Listen, I need you to talk to your attorney because, you know, you agreed to this provision, or you're now going to agree or not agree to this provision. I need you to talk to counsel about that because I'm just not, you know, I'm not that expert, okay? So by initialing the space below, all right, you are agreeing to have any dispute arising out of the matters included in the Arbitration of Disputes provision, which was that previous paragraph, decided by a neutral arbitration as provided by California law, and you're giving up any rights you might possess to have the dispute litigated in a court or jury trial. Now, folks, I'm going to tell you something. I like going to court. I get a lot of money for going there. It may not be a good place for us, okay? As real estate agents, just nothing ever good comes from there. And by the time we get to that point, it's usually the money's gone anyway, right? So, but it happens, okay? So you're giving up your right to have it disputed in a court or a jury trial. So I made this comment, I've made it a couple times over the decades here with two attorneys. I'm saying, I just never met a jury of my peers. I mean, if you look at some of the juries, I just go, I don't know. I mean, how are you going to find somebody that knows what I know, you know, and I don't know that much, but I do know this, right? So I always worry about a jury of my peers, okay? So, and I say that with tongue in cheek, you know, it's just in fun, but sometimes I don't know. Where did you come up with that? Okay, so by initialing space below, you're giving your rights to discovery and appeal, except we're going to see that's not true, unless those rights are specifically included in the arbitration of disputes, which they were. Okay, if you refuse to submit to arbitration after agreeing to this provision, after you've done it and they've done it, okay, then you may be compelled to arbitrate under authority of the California Code of Civil Procedure. Your agreement to this arbitration provision is voluntary. So just like my liquidated damages provision, I might not want to be telling my client that it's in their best interest to sign arbitration. And we need to be careful about that, because we frequently get hit with that when the client says, should I initial that? And it's like, well, I think it's a decision for you to make. It's a personal decision for you whether or not you want to do it. But then again, I'm flashing back to, gee, the listing agent's going to send it over saying they want it initialed, and then I'm going to have to be looking at the listing agent going, did you explain this to your client, or is this like your personal policy? Okay, so frequently, this is one of the reasons we took the arbitration provision out of the listing agreement and out of the buyer representation agreement, because a lot of our brokers were saying, God, you had the client agree to arbitrate with me, and I'd rather litigate. And so we just decided that it can't be put in there anymore, because agents were having their clients initial it by default, when in fact it might not have been in the broker's best interest. Okay, but we left it in the purchase agreement because we want it included in the right to do it to the buyer and the seller, but we didn't necessarily want to make it compulsory for us as brokers in the buyer representation agreement or in the listing agreement. So the sad truth of it is, and we knew it would create this problem, when we took the provision out, we put it on a separate, ARB form, a separate form. We knew that everybody's just going to forget about it. Okay, just like we forgot about the wood destroying pest addendum, we just forget about stuff like that, and then we just move forward. We're just so excited to get the listing signed, or hope that it's going to get signed, that we forget it's a little more complicated than that. So is everybody good with me on this? This is again a complicated provision, but it's an important one. Okay, so you need to have the understanding of what it says, and I'm going to tell you, you're at the 400 level here right now, folks, because I don't know a lot of people. I can sit down in a room full of attorneys and we'll get this right. Or if your broker's been involved in a lot of litigation, and if you're a larger broker, chances are it's just part of doing business, and you're probably going to understand this better than most. Our meeting yesterday, there were a couple of really big brokers in there, and they just sit there and go, oh, yeah. And so, you feel like a ping pong ball at some point, but it is what it is, and it's just part of the rags and riches kind of theory of owning a brokerage. So this is one of the reasons I tell people to get your broker's license, but resist the temptation of opening up your own firm. I say that all the time. Okay. Oh, hi, John. When we send or resend to clients, should you recommend that we make the DocuSign initial optional? Okay, great question, John. So the way we have created zip forms, the initials are optional by default. So and your question's a really good one. I would not go in and make them required. And the reason that we created the optional initial field, because it wasn't optional before the original zip forms product did not have, DocuSign didn't have it, Digital Ink didn't have it, did not have optional initials. But we ended up creating the optional initial fields because we didn't want people to think that they were supposed to initial it. Okay, it's like it has to be a personal decision. It has to be something that they decide to do. So we created the optional initial tag in the program so that people could skip over it. Now, what happens 99% of the time is that the buyer goes to sign everything and then skips over it, right? They hit the tab button because they were able to, and they skipped it. And now the listing agent and the seller get a document that has no liquidated damages, no arbitration. And so they assume that the client skipped it accidentally, when in fact the client might have skipped it intentionally. And that's why I say we want to be careful that we think we know what the client is thinking, but that's why I always have that conversation with the client ahead of time. Be aware 21 and 22 are going to be paragraphs that you're going to be asked to initial, but it's a personal decision for you whether to do it or not. Forget the fact that the listing agent may come back with you and require it. That's not their, I'm saying that, but it's really a seller supposedly requiring it, but they're doing it based on, advice and counsel of the agent. And so, like I said a second ago, it may not be in your client's best interest, but that's why we have it as an optional field. And so I can't answer the question, should you initial it or not initial it, but not on the resend. To say a seller always requires a conversation. Yeah, absolutely, John. You hit it. You nailed it. Okay. So the point is that we want to make sure that the client is aware of the fact that they can initial it or not initial it. If the seller requires it, and we just have to assume that the agent has advised the seller of what it means, that now your buyer has to make the decision whether or not they want to be bound by it. Okay. So and that's a big decision. All right, it really is. I mean, like I said a minute ago, listen, I'd rather go to court. I I love going to court, okay? But you know what? It's doomsday for us as real estate agents, because by the time we get into court, the money's all gone, right? Because, you know, your commission, forget it. You know, you had to pay your deductible, you had to do all that kind of stuff. The commission's just gone, right? And the broker's going to hold it up or do whatever they're going to do. So, you know, at the end of the day, the legal system being what it is, it has the best of intentions, but like everything else, it doesn't always come out that way. So the answer is, yeah, I'd have if you get a counter offer back from the listing agent that says we want that initial, if they even catch it, right? We want it initial. Remember, if they don't initial it or they don't address it, then it doesn't apply. So there is no arbitration, there is no liquidated damages. So we got to be careful that we know what we're doing and we're looking, you know, but you'd be surprised how many times it gets skipped over. Can you have seller sign, but buyer doesn't sign the arbitration? Yeah, sure. Seller can say, I want it to apply. And the buyer says, no, I don't want it to apply. But like I said a second ago, a lot of times it's just, you know, the assumption is that the buyer just skipped it accidentally, you know, because you can't go back in the program. You're not able to tab back again. You can only tab forward. So once the buyer skips it, you know, then they can't go back and fix it. And then the seller again has to address it in the counter offer, otherwise it doesn't apply. So if the seller wants it to apply, then they have to address it in the counter offer. Otherwise, if one party initials but the other doesn't, then it doesn't apply. So the seller has to do that. So the prudent listing agent who has been taking these classes on how to write counter offers knows that they need to make sure that they write in there that if the seller wants it to apply, that the buyer is going to have to agree to that. And again, when I do that counter offer part, if my seller says I want the buyer to initial it, then I'm going to reference paragraph number 22, paragraph number 21. Buyer and seller agree to initial paragraph number 20 and 21 and 22. You know, that kind of thing. I'm going to reference the paragraph, and so that's, I always like to link them. It's very clear what paragraph 21 and 22 say. I can just hold the document up, and I assure you the judge does. So good question, Dawn. And John, thank you. I was glad you asked that question because I might not have answered it by myself. Okay, everybody good? We've read and understand the foregoing, agree to submit disputes arising out of the matters included in the arbitration disputes provision to neutral arbitration. 10-point bold font. So the law says that it has to be, if it's going to be in the same size font as the rest of the contract, the law says it has to be in red. Okay, but since we just kind of assume that you don't have, that your document is going to print in red, because you know, we still have people wet signing things, you know, on paper, that kind of thing. So we just said, okay, the law says if not in red, then in 10-point bold font, and that's why we do it in 10-point bold font. So little trivia information there in case you wanted to know what that meant. Any other questions about any of that? You're all asking really good questions. I'm telling you, I'm glad you're asking these questions. Some of the stuff I forget, and it's like, you know what, it's incredibly important. Okay, we've got paragraph number C. I'm going to try to get this going here. Paragraph number C. So additional mediation and arbitration terms. So let's talk about exclusions, and this is important. What is excluded? And it's going to be pretty simple. You're going to see, okay, I get it. A judicial and non-judicial foreclosure. So, folks, it says judicial, which means it's the court. You can't get the court to agree to mediate. They're not going to, they're the court. I was getting a kick out of that. Well, we can make the court mediate. I don't think so. Okay, here's mediation, here's court. So anyway, the answer is no, or any other action to enforce a deed of trust, mortgage, or installment land sales contract. We, you know, don't do land sales contracts, even though they're on the state exam. Okay. Number 2, an unlawful detainer. Right? Separate court for that, right? Number 3, any matter that is within jurisdiction of who? Probate, small claims, bankruptcy. This is why I go crazy when somebody, you know, puts in a deposit on an earnest money deposit on $1 million house for $10,000. It's like, guess what? If you guys get into a fight with each other, and I've got it going on right now, you get into a fight with each other, you're going to small claims court. I'll do everything I can to get this up into superior court, but even the lawyers look at me, they go, what are you trying to help these people for? You should have gotten a bigger deposit. I'm like, I know it. You know, what do I have to do? So, if it's $1 million deal, I don't know if I'd have a $10,000 deposit. Okay. I don't know if I would do that. 1%, really? Because it just doesn't make it worthwhile. Now you're going to small claims court. And frankly, I don't get involved if it's one of our clients disputing with another client, I don't get involved in it. So it's like, you know, I don't know what you all did. Did you ever get it figured out? And it's like, you know, I told you not to do $10,000. Okay. Everybody good? I mean, I'm sorry, I get a little animated about it, but it's because I really think you need to be putting serious money in. I think if you're doing $1 million deal, and thankfully in this economy you have so many offers on stuff that buyers are putting in more money for deposits, those kinds of things. But again, we need to have the limits to the liability, and we need to have them in writing and signed by all the parties, or else we're going to have other issues later. So okay, let's wrap it up here. We're going to talk about the final part, which is preservation of actions. Okay, so number 2 here is preservations of actions. So the following shall not constitute a waiver. In other words, even though you do what's coming, it doesn't say that the rest of this before this is going to go away, nor a violation of the mediation and arbitration provisions. So number 1, the filing of a court action to preserve a statute of limitations. So in other words, when does the lawsuit get filed? And we all know this, right? And so generally the statute of limitations in a real estate lawsuit generally is 3 years, right? So when is the lawsuit filed? It's filed at 2 years, 11 months, and 15 days. It just is. And that's why I tell you to write everything down, save it in zip forms, because you need to have your defense set up now for the lawsuit that could be coming in 3 years, because you can't remember. You can't remember what you had for breakfast 3 days ago. So you need to take all of your emails, everything incident to a transaction, print it, save it as a PDF, whatever, put it into the zip forms program, put it all in one place. I've had this conversation with Veronica, the deputy commissioner, and she said the same thing. She said, yeah, have it in one place. That way you're not going to run around looking for it. And they consider zip forms to be secure, even though you and I know it's probably not so secure, but they consider it to be secure. So anyway, I met with her yesterday. It was a great meeting. I remember her saying once that, it's okay to use Gmail. We're going to say it's okay, but the minute you know that your account's been compromised and you continue to use it, we're going to say that was stupid. And so we're going to maybe sanction you if we find out that there's a problem that was created by that, okay? So filing a court action to preserve a statute of limitations, filing a court action to enable a recording of a what? Pending action, otherwise known as a lis pendens. Okay, my favorite word, lis pendens, for order of attachment, receivership, injunction, or other provisional remedies, or a mechanics lien. Okay, so those are going to be things that are not going to stop, everything we've just said. In other words, this is all going to be, it's okay to do these things, all right, only because you want to stop the time period from moving. Okay, and then finally, brokers shall not be obligated nor compelled to mediate or arbitrate, and I already kind of spilled the beans on this earlier, nor compelled to mediate or arbitrate unless they agree to do so in writing. So in other words, if there's a dispute between the buyer and the seller, I have said I think the broker should go, but that's not legal advice. I'm just saying I kind of think I'd like to be there, because I know that when these two come up with their award, and part of that award is I've got to pay $50,000, it's like, well, if I wasn't there and now they're litigating against me for 50 grand because the judge said or the arbitrator said, listen, I think I need to be there. Okay, I haven't had that luxury. I haven't had to do that. I don't know, people just don't want to do that with me or what, but at the end of the day, I'm going to go. But besides, I like being there. It's not a nerve thing. I put on a tie, I got a suit, the whole thing. I look good, right? Okay, so unless we agree to do so in writing, okay? And remember, it is your broker's decision. So if you are a salesperson for the broker, it's the broker's decision whether or not to do this. All the way throughout all this, we've seen broker. It is not the individual agent's decision. And the broker can say, we're going to just go ahead and cut them a check rather than go to all the other expense. And you know what? That's an economic decision, right? Sometimes it's easier. I mean, we have it in the law, we have this principle that says that a nuisance lawsuit is 10 grand or under, right? So they know, the attorneys know that if they send you a demand for 10 grand, you're probably just going to pay it because it's going to cost you more to have your attorney respond to it than the 10 grand. So a lot of times that's what people are thinking, is that 10 grand is kind of like that. And I don't know, today it might be 20 grand. I don't get any of those. But at the end of the day, there is a number where it just doesn't make economic sense. You as a salesperson may have input on that, but the ultimate decision is going to be your broker's decision, okay? And that's just the way it is. And if you don't like it, become a broker, be your own broker, okay? All right, remember what I said, get your broker's license, resist the temptation of opening up your own firm. Okay, any broker participating in mediation or arbitration shall not be deemed to be a party to the agreement. So even though you agree to go go attend the event or agree to participate in the arbitration or the mediation, even though you agree to do that, it still doesn't make you party to the contract. You're only there to defend your other rights that you have and your interest in the case. Okay, so again, you are not a party of the transaction, so therefore you should not be a party to the lawsuit between the parties. But you always want to run that risk. We always want to be thinking, okay, well, what are they going to say? And it may come up with some kind of crazy, formula that says that we were somehow responsible for all that. So, and again, I want to hear what everybody is saying. I just had this happen, the buyer and the seller, the buyer ran into the seller at a new construction, at a new build, and they had a conversation with each other, and they came up to an agreement on what they wanted to do. And then I get called by the buyer saying, hey, write this up. And I go, write what up? And they go, well, here's what we agreed to. And I said, don't be telling me this on the phone. Send me an email. Well, and even though they sent me this email, what a mess. But, at the end of the day, I wrote it up and the other side said, that's not what we agreed to. See, and that's why the law says, statute of frauds says, okay, that an interest in land, in order to be enforceable, must be in writing. So we need to see this in writing. And so it's really important that you do that. It's really important that you protect yourself and you protect your broker. Can you have seller sign? Oh yeah, okay, we talked about that already. Okay. Yeah, we need to have it in writing, folks, because remember, you can have a handshake to sell a property. You just can't enforce it. All right. And those are really important words. Okay. Because, the law doesn't like parole evidence rule. The law doesn't like, the he said, she said. They want to see it in writing. And the court's going to say, well, you could have put it in writing. You could have hired the broker. It would have cost you nothing to have the broker do it. Right. But you didn't, you chose not to do that. So I don't know what to enforce other than maybe now I got to piece it together, stitch it together over what your actions were, confirmation of acceptance by ratification. You started doing things as if there was a contract and things like that. So, folks, I just want to make sure that you understand that nothing is for sure, but you have to for sure do things certain ways, and you have to put it in writing. So, thank you all again, and take care for now.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.